Are ready to go. Thank you very much. We've got a nice turnout today of people from across Ontario who tuned into the broadcast, as well as a few people out east in Halifax, a few people in Calgary and Vancouver, as well as a couple of people south of the border. So thank you very much for choosing to spend the next hour with us as our panel looks at the top insurance cases from the courts in 2016. My name is Keith Gallup. I'm the Director of Client Services at Kelly Santini. I'm going to moderate today and hope all the technology keeps on working. If you're on our mailing list, you hopefully receive on a quarterly basis our risk report, Rulings Insurers Should Know. It typically contains about 15 reports on court rulings from usually Ontario that affect insurers with a synopsis of the case and what those rulings will mean for insurers going forward. So today, our panel has gone through all the cases from 2016, several dozen, and picked out their selection of the top cases, those that will have the most influence on insurers in 2017 and beyond. Our panel is 3 of the 15 insurance defense lawyers at Kelly Santini. We have Shawn, Krystal, and Samantha, who have each selected their cases, their top cases from 2016. All 3 have active insurance defense practices across property and bodily injury claims. Shawn also acts on employment and construction-related claims. Samantha's recently been active handling a number of large flood and oil spill files. And Krystal's practice includes some work on some complex fire losses as well as oil spill subrogation. So this is how we're presenting today. We have broken down the cases into 3 areas: bodily injury, procedural, and property. Each have selected one case from each area that they think is the most influential in that area. And so we're going to go through and present 9 cases in total. And then at the end, our panel will be asked to select their one most important case from 2016 and why. And then we'll put it to you, everybody listening in, to decide which is the most important case from 2016 for insurers going forward. So Samantha, you won the coin toss. If you would give the wheel a big spin to see which category we're going to deal with first. There we go. It is bodily injury. So I will turn it over to Samantha with the first case.
Great. Thank you very much, Keith. Good afternoon, everyone. I'm very pleased to be here speaking to you today about some of the most important cases from 2016. The case that I've selected in the bodily injury matter is the Daggett and Campbell case. This case deals with expert witnesses, and what it really brings to the forefront is the court's growing concern with the bias of these types of witnesses. So that's why I selected this case. I'll give you just a little bit of background on it. This case arises from a rear-end motor vehicle accident. The plaintiff in this matter suffered some soft tissue injuries, sleep disruption, headaches, reduced range of motion, and also some depression. The case, the decision that I'm referring to arises because the defendant sought an independent medical examination by a psychiatrist on this matter, and the plaintiff refused and did not want to undergo this IME. The plaintiff had undergone some psychological treatment with a neuropsychologist and had a report of a psychologist, but had not seen a psychiatrist. And so that was one of the grounds for which the plaintiff based their refusal to undergo this IME. Another ground for this refusal was the fact that the plaintiff found the defendant's expert, Dr. Monte Bale, to be biased, and so did not want to undergo an IME with this psychiatrist in particular. In addition, the plaintiff stated that had the defendant gone ahead with this IME, they would also have had to retain their own psychiatrist to obtain their own report responding to this examination, and that this would delay a trial which was coming up about 5 months after the motion. So the defendant brought a motion to try to force the plaintiff to undergo this IME with Dr. Montebail. And it's really interesting. The case itself is really quite interesting in that the court discusses some of the recent cases dealing with expert reports, and it really brings to the forefront the court's concern about these hired guns, as they're called, whether they be retained by the defense or by the plaintiff. But the concerns of the court with these biased experts, and the fact that these expert findings and these reports are simply not useful to the court because of the bias of the expert. Now, interestingly enough, Dr. Montebail was found to not have been unfair or nonpartisan in previous cases, and this was mentioned by the court. There were many of them. Paragraph 29 of the decision lists all the cases where this doctor was found to have been not fair in the assessments. And so, it becomes interesting to see that the court is taking into account these other decisions. In the end, the court decided not to allow the defendant to obtain the IME by Dr. Montebail. And I think that the real message here is, number one, when looking to retain an expert, you must do so. You must choose your experts carefully. And while it doesn't occur very often, the courts will take note of the expert's testimony and other decisions, and it could affect their ability to serve as your expert in your trial. In addition, the court will be more likely to refuse an expert or an expert's report where obtaining such will cause you to delay a previously scheduled trial date and will delay the litigation in the future. So, number one, be sure to have selected an expert who's not been previously found to be partisan or biased in other assessments, and to try to do so, to select your expert and have the IME done with a good amount of time, a fair amount of time before trial. And if you're looking to retain an expert of qualifications that the other party has not yet seen, that the plaintiff has not yet seen, as in this case a psychiatrist versus a psychologist, you may need some evidence as to why it is appropriate for you to have obtained an IME by this professional. And so I found this case to be of importance because it deals with experts and spans really all types of litigation here.
Great, thank you, Samantha. And next up we have Krystal.
Thank you very much for inviting me to sit on the panel here today, guys. This is a great opportunity. I have reviewed all the cases that were on the Kelly Santini website, and I've come up with my favorites. The first one I chose is Watson-Bowman. It's a case on implied consent. So I'll give you a little background about the facts. So the starring role in this drama is played by a young woman named Amanda. Amanda was involved in a motor vehicle accident in October of 2011 while driving her mother's car. So the plaintiff suffered a broken wrist. It's not a huge injury. Amanda was completely at fault. There was no question on liability. So liability and damages were agreed on. The matter went to trial on the limited issue of whether Amanda had implied consent to drive her mother's car. If she had the consent, then her mother's policy would pay. If she didn't, then the accident was considered an uninsured vehicle, and the plaintiff's own policy would have to pony up the money. So the evidence at trial showed that historically, Amanda had borrowed her mother's car on 5 occasions when she had lived at home. In the 3 years after she moved out, Amanda borrowed her mother's car twice. On all occasions, the rules were set out that Amanda was required to ask permission to use the vehicle, advise where she was going, advise how long she'd be gone, and what she'd be doing with the car. So sometimes, for whatever reason, her mom would say no. Sometimes when Amanda asked to use a vehicle, her mom would say, hey, let me drive you. I'll drive you where you want to go. On that fateful day in October 2011, Amanda was dropped off at her mom's house by her boyfriend, expecting that she'd be able to ask her mom for permission and she'd get that permission to drive the car. Unfortunately, her mother had just undergone chemotherapy and was asleep. The evidence was that Amanda tried to wake her, but she was unable. But Amanda had places to be. So assuming that her mom would sleep for hours and wouldn't need the car, and assuming that she would have been granted permission, she took the car. In fact, at the trial, mom actually testified that she probably would have let her daughter use the car. So the trial judge confirmed that the test of implied consent is not subjective. It's not whether the driver thought she had implied consent with the owner, or even if it might have been granted if she had asked. The test is whether she actually had that implied consent at the time of the accident. So as much as the court will take the belief of the parties and the intentions of the parties into consideration, it's got to look at all the circumstances. In this case, there was no certainty that mom would have let her use the car. Her response could have been yes, could have been no, could have been I'll drive you where you want to go. So in the circumstances, Justice Corkery concluded that the daughter did not have implied consent to drive on the day of the accident, and as such, the plaintiff's insurance company was required to pay. When I look at this in my circumstances, I look at my husband and I share a house with a single lane driveway. We have 2 cars. So we often have to either switch up our cars, or my husband will take my car. He'll tell me where he's going. I'll normally let him. Sometimes I say, hey, I've got errands to do too, let's go together. Sometimes I'll say, no, I've got an appointment in the afternoon. So in the circumstances of this case, because there's a question of what my answer would have been, my husband, if he took my car without my express permission or without some other kind of agreement, he would not have my implied consent when he gets, or if he got into an accident. So I think the takeaway from this case is if the driver of the vehicle involved in the accident isn't the owner, there could be an issue of consent. So in investigating the loss, when you're taking a statement, when you're conducting an examination under oath, get as much detail as you can. Get information about the relationship between the parties, prior permissions given to use the vehicle and what circumstances, any denials for the use of the vehicle, like what those circumstances were, why was the permission denied, and get any restrictions that the owner would put on the use of the vehicle, like where they're going, what time she would be back. And I think if we get as much information at the start of a file, then later on, if this matter goes to a trial and the issue has to be determined on implied consent, this will be very, very assistive to counsel on the file. So that's why I think it's an important thing, because this could apply to not just mother-daughter, not just kids and parents, could apply to any kind of situation where the owner is not the driver of an accident.
All right, thank you, Krystal. And now we'll go to Shawn for his pick for top BI case.
Welcome, everyone. I've chosen Gardiner and MacDonald, which, as you can see from the bullet points, is a trial involving the liability issues arising out of a collision between a city bus and a passenger vehicle. There were also 4 pubs named as defendants. So the reason for this fight was that initially the car driver's insurer had denied coverage because the car driver's use of alcohol was a violation of the terms of the G2 license. The insurer subsequently agreed to pay their $200,000 statutory minimum limits, but this left a shortfall because in this collision there were 3 fatalities and 1 catastrophic injury. And so the issue was who pays? City of Ottawa as the bus owner or the OPCF 44? So let me tell you a little bit about the facts. The bus driver's testimony turned out to be pivotal in the trial judge's decision. The bus driver said that he, at about 1,500 meters from the intersection, he saw the light turn green for him, and he saw an SUV, a car, approaching from the right that looked like it had its brake lights on and looked like it was slowing for the red light. Now, the bus driver said that in keeping with common bus driver practice, he looked to his right and looked to his mirror on his left before looking straight ahead again as he entered the intersection. And as he entered the intersection, he noticed that the vehicle to his right had not stopped at the stop line, was right at the corner of his bus, and he testified he thought it was about 7 feet away. He took evasive action, but there was a T-bone collision. The only other passenger on the bus testified, and that passenger was an off-duty bus driver who was being shuttled back to the main station. He said that the driver of the bus said out loud as they approached the intersection that that approaching vehicle was not going to stop at the red light, and that there was a very small window of time between seeing the other vehicle in the intersection and the impact with the bus. The passenger said he felt the brakes coming on hard, and also had testified that before entering the intersection, the bus had not decelerated. 3 collision experts testified at the trial. None of them could agree on the pre-impact speed or the actual impact speed, and the range was anywhere from 55 kilometers an hour to 85 kilometers an hour. Now, red light law is something we've known since 2014 in Sant and Seacon, where the Court of Appeal said that even if a driver goes through a red light, the other driver with the right-of-way still has a duty to exercise reasonable care to avoid a collision. So that part's not new. What was new in this case was the fact that there was a professional driver. And so the court looked at the evidence of the weight of the bus. It's 12,000 kilograms. The fact that this was late January in Ottawa, so there was the effect of wet and snowy roads. And all of the experts testified how those factors interplayed with the ability of the bus to stop and take evasive measures. One of the things that the features of the bus was it had GPS. And so as a result, the court was able to tell that this bus at various points was traveling at 65 kilometers or more in a 60 kilometer zone. But the court said speed per se wasn't negligence. The speed of the dominant driver is a factor in answering the question of whether they exercised reasonable prudence in the circumstances. The court said at trial that the dominant driver should yield when the dominant driver is aware that the other driver is going to go through the red light, and the dominant driver has an opportunity to avoid the collision. So again, we see that in Sant and Seacon. But the trial judge, the appellants argued, had put too high an onus on the bus driver, had perhaps elevated him to the status of a common carrier, where he's almost the guarantor of the passenger's safety. And the Court of Appeal disagreed. The Court of Appeal said that the bus driver had admitted in his testimony that he was trained to drive, that he had a special license, and that he was in the course of his duties at the time. And the cross-examination of him was very important. He admitted in his testimony that his training taught him to respect the speed limit, to drive defensively by giving up the right-of-way if needed to avoid a collision, to make allowances for road conditions when driving, and to maneuver at a distance to preserve a safe stopping distance and collision avoidance distance. And the trial judge said that she didn't need expert evidence on this standard of care because this was a matter of common understanding. And what she was relying on was that the driver's evidence of his training informed the duty of care in the circumstances. She stated that he alone controlled the maneuverability and capacity of a vehicle that weighed in excess of 12,000 kilograms. The training he was required to pursue to obtain and maintain his Class C license and the experience he acquired over 27 years of driving prior to the accident obliged him to consider all of these factors and act in such a way while driving defensively that would not invite risk or preclude his ability to stop or steer the mass and weight of the city bus away from the hazard presented by the oncoming vehicle. And the Court of Appeal agreed with that. The driver was cross-examined on the manual. The trial court held that the things set out in the manual are not mandatory, they're not absolute requirements, but again, they inform the standard of care in the circumstances. The expert evidence, at least 2 out of 3, showed that in the time that was available to him from when he first detected the SUV, there was an ability to avoid the collision if he had been traveling at the speed limit. And the avoidance was that SUV would have passed in front of the bus without a collision. So the court found that the GPS evidence, the evidence that when the bus driver was 180 meters away from the intersection, he was exceeding the speed limit by 5.6 kilometers an hour. The fact that he didn't slow down because of the weather were all factors which led to a basis of finding of causation. And the court said that if his failure to react in a timely manner wasn't the issue, rather it was his failure to adjust the driving to the weather and the road conditions, and in the circumstances perhaps to deviate from the procedure set out in the manual, which required him to check his mirrors before looking ahead before entering. So the takeaways are that although the fact that the driver being trained as a professional won't set a new higher standard of care, it will inform that duty to avoid a collision that the court set out in Sant and Seacamp. And so the court found that there was 20% liability on the city, and of course that meant that the city ended up picking up all of that shortfall. What's important for insurers in these cases where you have a commercial driver or you're defending a claim where there's a commercial driver who's involved is to look at the training that that driver's got, to get that training out and get those admissions at discovery, to find the manuals that tell the driver how to drive and how to drive defensively and get that evidence before the court. In this case, the expert evidence of the weight of the vehicle and how it impacted the stopping distance and the defensive driving was really important. And if we can develop those things, you will be able to develop a better contributory negligence case and perhaps, in the case of the OPCF 44, avoid liability on your policy. Thank you.
All right, that concludes our look at VI, and now we're going to move on to the next category. Krystal, you won this toss, so if you want to give the wheel a big spin, and we'll see. We're going ahead with procedural. Krystal, over to you.
All right, for looking at procedural cases, I found one that I thought was very, very interesting, and it's State Farm versus Aslan, and it's a case about an examination under Section 33 of the SABS legislation. And what's so interesting in the facts, which I'm going to tell you about, State Farm had 7 insureds involved in 7 separate accidents between 2011 and 2013. The claimants, as far as we know, didn't know each other. The only link between them was that they all had the same lawyer. And it turns out that all 7 claimants were each using the same 2 service providers for attendant care. So that wasn't a problem until February 2015, the claimants submitted expense forms with receipts for attendant care. And as you know, claimants have to sign the form saying that the information they are providing is true and correct. However, State Farm went through the receipts and found that one service provider who was providing attendant care to 3 of the claimants invoiced 113 hours per week. That is 16 hours per day, 7 days per week. Obviously, State Farm was very worried that this poor attendant care provider was going to die of exhaustion, or perhaps something was hinky. The next month, in March of 2015, the receipts for one of those 2 service providers for 2 claimants was in excess of 93 hours per week. That's double the hours for a usual work week. Ding, 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 ding. You know, that obviously raised some red flags for State Farm. So they decided to conduct an examination under oath pursuant to Section 33 of the SABS. State Farm wrote to the lawyer for all 7 claimants, indicating that we're going to conduct an exam for the purposes of determining whether State Farm is liable to pay benefits. Counsel refused to produce for 7 clients on the basis that all 7, imagine that, all 7 were incapable of being examined due to mental and psychological reasons. Like, that is some terrible luck. All 7. Anyways, the examinations under oath were canceled, as it was clear the claimants would not attend, so no formal notices were actually served. But State Farm brought a motion to compel the insured to attend an examination under oath. At the hearing, the insured lawyer opposed the motion on the basis that her clients were incapable, but also on the basis that State Farm failed to provide proper notice as the reasons for the examination were not set out. So at the hearing, State Farm produced a standard notice, which was broadly worded and noted that it covered everything from details about the accident, details about all benefits, and any medical treatment being received. So Justice Hackland found that Section 33 of the SABs, it sought to achieve a balance between the insurer's right to properly determine a claimant's right to benefits with the insured's right to convenience and fairness. And by fairness, he was talking about reasonable advance notice of the examination, a right to counsel, and the advance notice of the reasons for the examination. Justice Hackland found that a generic statement of the reasons wasn't going to cut it. So instead, he concluded that the notice should have indicated that the examination under oath was to review the claims for attendant care. And that would have allowed the insured and counsel to prepare or to come prepared to discuss the issues that were raised and to produce any documents that might be relevant to those issues. Now, Justice Hackland, he's been in the business a long time. He's not new. He's not a dummy. He recognized that this would allow some claimants to tailor their evidence. And to address this, he recommended that, look, an examination under oath shouldn't be brought until a thorough investigation is done beforehand. So although it's not unheard of that a claimant admits to fraudulent activity during an examination under oath, it's less likely than a claimant abandoning their claim after being confronted with the evidence at an examination for oath, or examination for under oath. So with respect to the issue of capacity, he did touch on that. He said, look, if proper notice is given, the claimants have to attend unless they prove they're incapable because of physical, mental, or psychological conditions. So if the incapacity is being relied on, it has to be supported by affidavit evidence with medical support. And the affidavit of a lawyer just attaching a medical note won't cut it. That is not sufficient evidence. So the affidavit's got to be by a doctor or the claimant themselves with supporting medical documents. So the takeaway from this is that any notices sending out must be specific about why the reason or reasons for the exam. So the information has to be sufficient enough that the insured and their lawyer can come prepared to discuss the issue and provide the documents. But I don't want you to think that this is the end of the story and this handcuffs you as far as what you can talk about, because Section 33.4.4 broadens the scope. So there's a different obligation for sending the notice and what scope you can of the questions that can be asked at the examination. So first thing you got to do is get them there. Ensure that you have the proper reasons set out in the notice, and then once you get them to the exam, go wild, ask all the questions you want.
Thank you, Krystal. And next up on procedural, we are turning things over to Shawn.
So I've chosen Cadieux and Saywell, which is also a decision of Justice Hackland, and it is the judge's post-trial rulings after a 7-week personal injury trial, which dealt with all those procedural aspects of deductibility, interest rates, management fees, and costs. And I like this case because it also brings in a Court of Appeal decision, which is very important on deductibility. So let me tell you a little bit about the facts. The plaintiff was a pedestrian who was walking along a roadway with the defendant, Saywell. The plaintiff and Saywell get into a fight, and Saywell pushes Cadieux towards the road, and of course Cadieux stumbles and is struck by an oncoming truck. Now, the truck driver settles with the plaintiff 3 years before trial at a global resolution with the SABS insurer. The settling truck driver, tort fees are paid $500,000, and the SABS settlement was $900,000. Now, the plaintiff was under a disability, so needed court approval for that settlement. And that meant that the SABS settlement details were all known and available to the court. Now, at trial, the jury awarded all those details were known at the trial. The SAB settlement was $300,000 for IRBs, $250,000 for medical benefits, and $350,000 for attendant care. And so Mr. Justice Hackland had to address what gets deducted from what? Because the jury had awarded past income loss of $133,741, future income loss of $971,000, and so a one-third liability, because the jury had said each of the truck driver, the plaintiff, and the defendant were equally responsible, so they assigned one-third to each. So there was, the plaintiff's damages were reduced by a third. So that's going to already bring us towards the cost issues, but before we got there, we had to look at the deductibility for the SABs. The jury had awarded for future care $23,000 for physio, $9,000 for OT, $4,000 for social work, $3,000 for a home gym, $50,000 for a taxi. The big item was acquired brain injury support worker, for which they awarded $701,000. So the fight was whether the future care costs awarded by the jury should be reduced by only $250,000 of the SABS med rehab in the settlement, or both the SABS 250 med rehabs and $350,000 attendant care. And this became all the more important because of the offers to settle that had been served 13 months before trial. Justice Hacklin found that the acquired brain injury support worker was a medical rehabilitation award and not an attendant care award. So the plaintiff said that the attendant care from the SABs did not match up with the ABI support worker award that the jury had made because it's not in the same category when you use the apples-to-apples approach. The defendant, however, pointed to Section 244(1) of the Insurance Act, which defines health care as being medical rehab and attendant care, and then pointed to Section 267.8, subsection 4, which says that healthcare tort awards are to be reduced by health care received from the SABs. And so Justice Hacklin looked at the Ontario Divisional Court decision in McCulloch, which said that past and future SABs are deducted from tort awards for future health care, and looked at the 2016 Court of Appeal decision in Basandra and Sforza, which held that the categories of deductibility must be taken as silos. So the Court of Appeal said that the Insurance Act creates categories. It says there are three: income loss and earning capacity under Section 267.8.1, healthcare expenses which include attendant care because of 267.8.4 and 244.1, and then thirdly, any pecuniary loss such as housekeeping. So Justice Hacklin went on to find that both the attendant care and the med rehab costs were in the same silo for deductibility purposes. So that meant that they got the full deduction of both against that ABI attendant care. There was another issue though, and that arose from the fact that the truck driver tortfeasor had settled 3 years earlier at the same time as the SAB settlement. So the plaintiff said, you don't get to deduct all of those SABs awards because I've already had that deduction applied to me once. And Justice Hacklin found that you only get to take the deduction. The plaintiff, only suffers the deduction once. He considered 267.8 and talking about when you do the deduction, but he said that didn't answer the question of what do you do when the defendants are found equally responsible and one's already settled. He had evidence in front of him, led by affidavits, that the tortfeasor who settled knew about the SAB's offer, and furthermore that his offer and the SAB's offer were put forward as a global take-it-or-leave-it position. So he found that, therefore, only half of the SAB's settlement was deductible from the jury award. When you crunch the numbers and look at the decision, you'll see that this was a case where the defendant had a near miss. They almost did better than their offer. And as a result, Justice Hacklin had to consider that near miss case law. And despite finding that the plaintiffs very reasonable partial indemnity costs were $494,000 plus taxes and disbursements after a 7-week trial. He awarded only $100,000 plus HST and disbursements. So the net to the plaintiff probably was, after paying fees, that he recovered very little. So the takeaway for insurers in this case is that you must find those details of what that SAB settlement will be. And you can get some help from that in doing it at discovery and obtaining future undertakings from the Court of Appeals decision in Bassandra and Sforza, where the Court of Appeal talks about the duties of counsel to ensure that the settlement of the statutory acts of benefit claims has an allocation, and we're not left in a fog of trying to figure this out. And so this prior position where plaintiffs saying, well, it was a lump sum, and since we can't tell what's what, there's no deductibility, doesn't appear that it's going to fly anymore in face of the Court of Appeal decision. The other thing I will tell you is that this case also throws in a discussion of what happens to those adjustments to the interest rates and the increase in the deductible after the collision but before the trial. And Justice Hacklin finds that prejudgment interest is a substantive right, the tort deduction is a procedural matter, but then of course says, I understand these are all going to the Court of Appeal in a few months, so that'll be part of our 2017 best case.
All right. Thank you, Shawn. We've got that to look forward to next January. All right, over to Samantha and your pick for procedural case.
Well, I almost wish that I had selected a decision by Justice Hacklin, because he would have had a sweep of this category for our picks for 2016, but I didn't. I picked a decision out of Thunder Bay, Skunk and Ketash. Now, the insurer on this matter is Jevco. And this case is an interesting factual case in the sense that this is a motor vehicle accident involving a husband and who was using his wife's car. So some similarities with the earlier case discussed by Krystal and the OPCF. But here's where things get even more interesting in this decision. So the husband borrows the wife's car, and then a friend of the husband begins driving the car without consent and is involved in a high-speed motor vehicle accident. The husband suffers some significant injuries, cervical and thoracic fractures, requiring the removal of vertebrae, as well as some bone grafting and internal fixation. So the court is faced here with a plaintiff looking for coverage under the OPCF for some pretty significant injuries. So the husband claimed that the car was uninsured or underinsured because the driver was using the vehicle without consent at the time of the accident. The real issue here then comes down to the definition of an uninsured automobile, which is defined by the Insurance Act, and it's defined as an automobile with respect to which neither the owner nor the driver has applicable and collectible bodily injury liability and property damage liability for its ownership, use, or operation. But here is the kicker. It's this sentence. But it does not include an automobile owned by or registered in the name of the insured or his or her spouse. So theoretically, because this was the spouse's vehicle, the vehicle should not meet the definition of an uninsured automobile. And this wording from the Insurance Act is also found in the wording of the OPCF 44R at section 1.11. It's basically the same definition of an uninsured automobile. So Jevco, in this case, refused to provide damages or to pay up to the husband because it stated that the car does not meet the definition of an uninsured vehicle, seeing as it was the spouse's vehicle. The court found otherwise, and in order to do so, what they really did was look at the real reason that the legislature had added this section, this last sentence here about the vehicle being that of the spouse, to the definition in the Act and also why it appeared in the OPCF 44R. And what they found was that it really wasn't to prevent someone in the situation of this plaintiff who was seriously injured and to no fault of his or of his wife's, the vehicle was found to be or was in fact uninsured. So the court, and maybe we could just change the slide. The court found that what the legislature wanted to do here was to prevent claims made by insureds from the use of their spouse's uninsured automobile where the lack of insurance was in fact caused by the spouse. So coverage shouldn't be granted where the insured deliberately chose not to insure the automobile and then their spouse uses the automobile and is involved in an accident. However, coverage in situations where the vehicle is considered uninsured due to no fault of the spouse, so for example, as in this case where the vehicle is driven by someone without consent, will allow for the spouse to claim under the OPCF 44R. This case is quite interesting in that the court spent a great deal of time reviewing the principles dealing with the interpretation of acts and of contracts. So, you know, we do often talk about how the court should go outside of the specific wording of the act when they need to in order to understand the real meaning of what the legislature was looking to accomplish here. And this is one of those cases where they did it. And so it sets out a lot of the interpretation rules and becomes quite important for that reason.
Thank you very much, Samantha. And now we have one category to go, which is property, and Shawn is going to lead off this last section.
Well, I'm going to pander shamelessly to our Alberta listeners, in particular to our Edmonton registrant, and I've chosen Ledcor Construction and Northbridge Indemnity. This is a builder's risk case. Ledcor, they were building Epcor Tower, which is the tallest building in Edmonton, and like all big glass towers, it uses a curtain wall system and has a window-to-wall ratio of 49%. That's a lot of glass. This case involves the cost of replacing all that glass when the window cleaners scratched it when they were doing the final cleanup at the end of construction. So at issue was the interpretation of the builder's risk policy, which was a multi-year blanket wraparound coverage which covered all the participants in the entire project. And the owner contracted with one company to install the windows and with another company to clean them at the end of construction. The cleaners managed to scratch all of the glass on the building in the process of cleaning it, and of course all of that glass had to be replaced. The trial judge held that the damage was covered by the builder's risk policy and was not excluded under the own work exclusion. Given the size of the claim, the matter, of course, went to the Alberta Court of Appeal. The Alberta Court of Appeal disagreed with the outcome of the trial judge's decision. The court used a physical or systemic connectedness between the work being done and the damage caused to interpret the exclusion, and to try and find the boundary line between making good faulty workmanship, which is not covered, and repairing resulting damages, which is covered. The Court of Appeal said that the policy excluded from coverage the damage that was connected to the faulty work, such as damage to the very object of work that was being operated on, or the part of the work being worked on. The Supreme Court of Canada released its decision in mid-September of 2016, and it upheld the trial decision with a very interesting minority judgment dealing with standard of review. And I almost chose this case as my most important procedural decision because the majority decision found that standard form adhesion contracts such as insurance policies are subject to a correctness test on appeal, and that the decision of a court below on the interpretation of policy is not entitled to deference. This gave the Supreme Court of Canada a clear path to interpret the policy. The Supreme Court of Canada observed that the plaintiff and the defendant had equally cogent but entirely opposite interpretations of what the policy wording meant, and they saw this as evidence of ambiguity. And the Supreme Court held that the lack of the definitions in some of the sections led to a finding of ambiguity in the meaning of the policy, and therefore the Supreme Court took the reasonable expectations of the parties and general contract interpretation principles into account, and it held the faulty workmanship exclusion serves to exclude from coverage only the cost of redoing faulty work. As a result, as the resultant damage exception covers the cost or damage apart from redoing the faulty work, and as such, the exclusion under the policy was limited to the cost of recleaning the windows, and the exclusion didn't catch the damage to the windows, and therefore the cost of their replacement was covered. The court found that the reality of the construction industry is that there's an ever-present risk of damage by one tradesman to the work of another, and that the coverage was intended to be broad. The majority's decision goes on to canvass and discuss all the previously leading builders' risk policy cases, and it's a very good roundup. The minority decision by Justice Cromwell points out an interesting problem with the majority approach by asking what would the result have been under the majority's approach if only one contractor was hired to do both the installation and the cleaning of the windows. Justice Cromwell finds that that the result may well be different and perhaps should not be. He does comment that courts should not make sweeping interpretations of common contracts like insurance policies because much will turn on the context and the surrounding circumstances. In the end, Justice Cromwell said that the trial judge's decision had no reviewable error and should be upheld. So the takeaway is that from this decision, appellate courts will get a complete clean slate, new kick at the can in interpreting the insurance policy provision. It has a wonderful roundup of the previous leading cases. It leaves us with a conundrum about faulty design and what has to be repaired, and tells us that's where the next battleground will be. Is the thing designed the work, or is the design the work? Stay tuned.
Thank you, Shawn. Next up we have Samantha with her property case.
All right, I'm going to talk to you about a case that deals with an insured's entitlement to actual cash value or replacement cost. And so this is a decision of the Court of Appeal. And in this matter, the plaintiff was an insured who owned a number of condominiums that were destroyed by fire. The insured had a policy with intact insurance, and the policy provided for replacement cost if the buildings were destroyed. They were completely destroyed, and the insured began to rebuild these condominiums and sought replacement cost. However, the insured made some significant changes to the layout of these buildings when affecting the rebuild here. For example, the size of the buildings grew from 51,000 square feet to 193,000 square feet. The height of the building went from anywhere from 1 to 3 stories up to 8.5 stories. And the number of residential units in the building went from 15 to 129. In addition, parking spaces increased from 42 to 165, and there were no elevators in the original buildings, but there were 2 in the new buildings. And so the insurer, I mean, these changes are obviously significant changes and improvements and expansions to these condominium buildings. And the insurer decided that, in their opinion, the insured was entitled to only the actual cash value, because the definition of replacement in the policy provides for the repair, construction, or reconstruction with new property of like kind and quality. So that is the real issue here, is determining whether or not these new condominiums meet the definition of replacement of like and kind and quality. Now, there were some significant numbers at stake here, because the actual cash value of the buildings was $3.9 million, whereas the replacement cost was $5.7. And so this was a significant, the decision would significantly affect both parties depending on how it turned out. And in the end, the Court of Appeal confirmed that the new condominiums that were being erected by the insured did not meet the test for like and kind, and therefore the insured was not entitled to the replacement cost, but would only be entitled to the actual cash value for this. So just because they were rebuilding these condominiums, the fact that they were changing them so significantly made it such that their policy would not cover replacement value.
Great, thank you, Samantha. And we will finish up with our last case of the day, and Krystal to talk about property.
Okay, the case I chose is Monk and Farmers. It's actually a 2015 Court of Appeal decision, but in case you think I'm cheating, because this is a 2016 case review. This decision was actually released late in December, near the holidays, and didn't actually hit the radar till early 2016.
All right, we'll let it pass.
And then actually there was renewed interest, because there was a new motion for summary judgment in the summer of 2016 that brought the cases back, and then there was a flurry of articles written about it. So, you know, I just want you to know I'm on the up and up. I'm in business when I'm here. But this actually is an interesting case, because it's one of the cases that they relied on in the case that Shawn was talking about, in the Ledcor case. So they reviewed this case in some detail in that judgment as well. But the facts are, the insured, Monk, hired a log restoration company to restore the exterior of her home. The process involved water blasting of the log, so the contractor was supposed to tape around all the windows, tape any cracks so that the water didn't get in. And it didn't. So there was damage to the carpeting, interior walls, light fixtures, you know, the inside was a mess. Mrs. Monk was insured under an all risks policy, which, as you know, covers perils subject to specific exclusions. This specific policy provided that faulty workmanship is an excluded provision, or it's excluded loss. It also, under a second provision of the policy, provided that we don't insure damage to property while it's being worked on, where the damage results from the work. And that section of the policy actually had an exception. It says, but we will cover resulting damage to other property that's covered. And this is a fairly standard provision in policies. But the insurer relied on these provisions to deny the insured's claims. So the plaintiff started an action for breach of contract against the insurer, and in turn the defendants brought a motion for summary judgment. So at the motions judge interpreted the faulty workmanship exclusion as excluding all damage done directly by the contractor and resulting damages flowing from that work. Basically, he found that under the provisions of the policy, there was no exception under the faulty workmanship section of the policy. So there was no exception for resulting damage. So he took the position that that was reflective of the insurer's intention, in that the insurer didn't intend for there to be an exception for resulting damage, because if they did, it would have been spelled out in the policy, obviously. But so as a result of that, the motions judge dismissed the plaintiff's action. This matter went to the Court of Appeal. And the Court of Appeal applied the correctness standard of review and ruled that the faulty workmanship exclusion should be interpreted narrowly and not so broadly that it would deny coverage for damages that an all-risk policy is intended to cover. And in fact, the Court of Appeal looked at the section and says, look, if you look at the faulty workmanship exclusion and you include it or interpret it to include both direct and indirect resulting damage, then the two exclusion clauses, the faulty workmanship and the damage to property being worked on, are in conflict, and how can you possibly have that? So, contrary to the motion judge's decision, the Court of Appeal actually found the intentions of the insurance company don't matter. It's what's actually written in the contract, and you have to look at that contract as a whole. You can't just parse out one little section. So the Court of Appeal found, if the insurer wanted to exclude coverage for resulting damage, it had to specifically set that out in the contract. So they found, absent clear wording to the contrary, resulting damage from faulty workmanship is covered under homeowner's policy. And I thought this case was important because it puts a heavy onus on insurers to clearly exclude coverage with specificity in their contract. So when you're drafting, if you go back and talking to the people who make those big decisions, make sure that these issues are addressed. You can't simply rely on the absence of an exception for resulting damage. It's got to be included in the wording.
Great, thank you all very much. That concludes our look at our panel's look at the 9 cases from 2016 that will have an impact on insurers going forward. Now it's time to vote, and it's time for the panel to turn into debaters and pick their one case and give a 30-second explanation as to why it's their case of the year before we turn it over to you, the panelists, to decide who in fact has picked the case of the year. Shawn, what's your pick and why?
Ledcor Northbridge. It has general application to all standard form contracts in terms of how they'll be reviewed on appeal. It has a very interesting take on property damage, and it caused at least 2 decisions I know of from the Ontario Court of Appeal that were seeking leave to appeal to be sent back for a do-over.
All right. Samantha.
I selected Daggett and Campbell. The reason I picked this case is because it deals with the court's growing concern in relation to the partisanship of hired experts. It discusses the changes, the fairly recent changes to the rules and the requirement of these experts to fill out forms and to promise to be nonpartisan, but it also indicates that the court is reluctant to find these experts credible, especially when they have a history of being found nonpartisan in other not nonpartisan in other cases.
And finally, Krystal, your pick?
I picked State Farm and Aslan because, well, first off, now we know that attendant care providers are out there killing themselves for these hours. It's crazy how many hours they work, and they deserve some acknowledgement. But really, it's because examinations under oath are important tools, and especially in a situation where it's an accident benefits claim and there's no tort action, this might be your first opportunity to meet the insured, assess their credibility, and this is going to come into play if the matter goes to a mediation or arbitration. So, got to get your ducks in a row before you get there to ask those questions.
All right. We'll let everybody listening decide. Up on the screen right now, you should have your the poll, so you can tell us what you think is the most important case from 2016 that will impact your business in 2017 and beyond. So the results are starting to come in. Thank you, everyone. We're seeing half of you have voted. We'll just give it a few more seconds. I know.
I'm inching on Shawn here. I'm inching on Shawn. Let's see.
It's, we have a pretty clear. Oh, no, we have a bit of a rally from Krystal. All right, we'll give it 5.
It's not good to beat the senior partner.
3, 2, 1. All right. Thank you, everyone, for participating in that. We'll share those results right now. As you can see, Shawn and Ledcor,
it's a landslide.
In your view, is the most important case. That means Shawn gets bragging rights around the office for the next 12 months and the crown of case law guru for 2017. I'm glad to see it was a more than a full majority, so we don't have to worry about any voter fraud allegations as to why you couldn't quite why you couldn't reach that 50% threshold. Ladies and gentlemen, it's just turned 1 o'clock. We've hit the end of the hour. We were hoping to get bit of time for questions, but I still encourage everyone to please do submit any questions you have. You can either, of course, contact our panel, who would be more than happy to answer any questions you have about cases or files that may be sitting on your desk that might be influenced by these rulings, or some of the other many 60 or so cases we reviewed in 2016. Of course, you can use the Q&A dialogue box that is on your screen as part of this webinar service to submit questions. We will go through them and do our best to get back to everybody as soon as we can with those questions. As you're typing that in, one final note about Risk Management Council of Canada. Kelly Santini is one of 10 member firms of RMC. It's a national association of independent firms, all with expertise in insurance defense. So there's 10 members. There's representation in every province across the country, and lawyers that are called in all jurisdictions. If you do have matters that have an interprovincial aspect to them and are looking for some experienced counsel in another jurisdiction, by all means reach out to us here at Kelly Santini. We'll be happy to pass on our recommendations of people who can help manage that case for you in a different jurisdiction. RMC is hosting another webinar on February 15th. That's on the use of social media evidence at trial. If you're interested in that, there's full details on the RMC website, and you can see the address on your screen right now. And the last thing, the handout should be available, the copy of the slides that is from today's presentation, available through the dialog box on your screen as well. So I think we'll, it's 1 minute past 1 o'clock, so 1 minute late, but we'll wrap things up now. Thank our panel. Look forward to seeing your questions. And thank you all very much for taking the time to join us today for this webinar. The next risk report e-newsletter will be out probably in February. Thanks everyone, and wishing you all a great day.